Good afternoon, everybody, and welcome to the University of Chicago's first Monday Luncheon. For those of you who haven't met me, my name is Tom Miles, and I'm the Dean of the Law School, and it is my great privilege to welcome you to our first Monday's event, which, as you all know, is not always held on a Monday, but it is a great tradition of our law school on first Mondays to bring together our alumni and friends, and an opportunity to hear from distinguished members of our faculty, and for them to share their insights on the upcoming Supreme Court term, as well as their insights on general trends in courts and in the jurisprudence. So to our alumni, I give you a special welcome. Thank you for attending this event, and thank you for your engagement with the law school throughout the year. I'm especially delighted that we're able to do this in person. This is our first gathering of First Mondays in person since 2019. And to members of the media, I also extend you a great welcome. Thank you so much for joining us and for your interest in the University of Chicago. So I do bring you some news and greetings from Hyde Park. This week, we are welcoming the members of the incoming JD class, who are members of the class of 2025, as well as members of our LLM class, the LLM class of 2023. Campus is full of excitement and energy. It's a great feeling as we've reconvened, as always, at the start of the academic year, but especially this year, because I think we are starting this academic year really for the first time since 2019 with the least amount of uncertainty about the public health situation. So it's this moment of special vibrancy on campus, and our teaching and our activities have just about fully returned to in-person. And as all of you know, our students continue to receive an outstanding education at the law school, one that is grounded very much in law, but also has that distinctive University of Chicago interdisciplinary flavor. And of course, our graduates have continued their launch of outstanding careers, outstanding and outstandingly varied. I'll leave you with just one statistic that I think is particularly relevant for our gathering today. In the past few years, the percentage of our graduating class who have gone on to clerk in clerkships, especially federal clerkships, has reached all-time highs. The past 2 years, it's been 30% of the graduating class. And that makes me very, it makes me very proud of our students and their talents and the education they receive and our faculty. And as you know, if you've been to past First Mondays, you know that I could go on all day about the eminence and excellence of our faculty. That has continued to grow in recent years. The pandemic has not slowed us down. In fact, over the past 3 years, we have added 9 new members of our faculty, and I'm delighted that 2 of them are here today. The law school's faculty remain deeply committed to a deep intellectual inquiry in their scholarship and in their work, and also in a transformative education for all of our students. So I'm very glad that we have 3 members of our faculty here today. And let me introduce them to you, and then I'll hand it over to them to take away our program. First, we have Kurt Bradley. Kurt is the Alan M. Singer Professor of Law. He joined our law school last summer from Duke Law School, where he previously taught for 16 years. Kurt's research and teaching interests include foreign relations law, international law, federal courts, and constitutional law. He clerked for Judge David Ebell of the U.S. Court of Appeals for the 10th Circuit and Byron White of the U.S. Supreme Court. He has served as a counselor on international law in the Legal Advisor's Office of the U.S. State Department. And from 2012 to 2018, he was the reporter on the Restatement Fourth of Foreign Relations Law. From 2018 to 2022, he was also co-editor of the leading journal in the field, the American Journal of International Law. He graduated with an undergraduate degree from the University of Colorado at Boulder and has his law degree from Harvard. I am also delighted to welcome Allison Ziegler. Professor Ziegler is a clinical professor of law and the founding director of our Federal Criminal Justice Clinic. The FCJC, as we call it, is the nation's first and leading clinic devoting to representing clients charged with federal felonies and pursuing impact litigation in federal court and seeing systemic reform of the federal criminal system. Professor Ziegler also runs the Federal Bail Watching Project, and its aim is to reduce pretrial jailing She has testified before Congress about bail reform, and the FCJC's groundbreaking litigation has earned numerous accolades, including the Seventh Circuit Bar Association's Justice Stevens Award for Outstanding Public Service Work, and the 2020 Clinical Legal Education Association Award for Excellence. Professor Ziegler previously served as a federal defender in Chicago. She was a Prettyman Fellow at Georgetown Law School here in Washington and clerked for Judge Robert W. Gettleman. She graduated from Yale College and Yale Law School and holds an LLM from Georgetown. And last but not least, I'm delighted to welcome Josh Macy. He is an assistant professor of law at the law school. He joined our faculty in 2020, and he specializes in environmental law, energy law, and the regulation of financial institutions. Even though he just joined us in 2020, he has twice won the University of Arizona's Morrison Prize for the most influential environmental law article. In fact, he's the only person to have won it twice. Professor Macy also graduated from Yale College, the London School of Economics, and Yale Law School. He previously worked as an analyst at Morgan Stanley and clerked for Judge J. Harvey Wilkinson on the Fourth Circuit. So we have an incredibly accomplished and distinguished panel to share their insights with us. I'm delighted all of you are here, and I will hand it over to them to take it away. I'll welcome Professor Bradley to the podium.
Thanks, Tom, and thanks everybody for coming to our discussion about the Supreme Court's upcoming term. There's always a lot of interest in the new term that's coming up every year as we get to September and then October. I would say there's probably a higher than average level of kind of excitement, or in some circles, anxiety about the Supreme Court coming up in this term, largely as a result of the drama we saw from the last term, an unprecedented leak of a major Supreme Court decision, and then the decision itself, of course, overturning a very famous decision, Roe against Wade. We also have a new justice now on the court, Ketanji Brown Jackson. And I would say more generally, a certain kind of anxiety or excitement that this seems, based on last term, to be a court willing to make bolder moves in the law, more likely than in past courts to depart from longstanding precedent. Whether you're excited or nervous about this, it generates questions, and we've seen some discussion in the press, even by some of the justices recently, about questions of where is this likely to lead, what other big shifts are we likely to see in the law, and then even more broadly, what effects might this aggressiveness, if you call it that, might have on the court's legitimacy. And both Chief Justice Roberts and Justice Kagan recently actually talked about that question, had differing views about that legitimacy question. And we might be able to touch on some of that, particularly in the questions and answers at the end of our session. Each of us have picked out just a few cases. We can't cover the whole term, and of course the term is not yet even docketed. We only have the cases that are so far accepted for review. And we each have different areas of expertise. So you'll hear some snapshots about some pending cases. We've tried to focus on a few cases that are a little bit lower profile, not the ones everyone's talking about. But of course, we might have some opportunity to discuss those other cases during the Q&A. As Tom mentioned, my areas of expertise are in the foreign relations law area and in federal courts, federal jurisdiction areas. There's no real big foreign relations law case yet before the Supreme Court for this term, so I picked out a federal courts case to focus on, and it's called Health and Hospital Corporation versus Televsky. It's going to be argued in the court on November 8th. And one reason I picked it out is I think it highlights a number of areas of law that the Supreme Court has focused on in recent years that they might be coming together in kind of a restrictive way, and we'll have to see obviously how this particular decision comes out. So I'll touch on those other areas as well as describing this particular case. So the Tolevsky case, for those of you who don't know, it's a case under the Civil Rights Statute 42 U.S.C. 1983. This is a statute, most of you probably know this statute, but was enacted after the Civil War, shortly after the Civil War, and provides a cause of action for damages and injunctive relief for violation, and this is key language, of the Constitution and laws. And very importantly, as a practical matter, not only does it give a cause of action, but Congress has provided in modern times also for the recovery of attorney's fees for the prevailing party in Section 1983 cases. This particular case, the Televsky case, involves a person who had dementia and was living in a nursing home in Indiana. And most nursing homes in the U.S. are privately owned. This one happened to be owned by a municipality, and therefore was a state actor that could potentially be sued under Section 1983. Section 1983 only applies to actors who act under color of state law, so it's not normally available against private actors. Through his wife, Mr. Tolevsky sued the nursing home owned by a municipality under Section 1983, alleging that the nursing home had violated rights that he had under another statute called the Federal Nursing Home Reform Act that had been enacted in the 1980s. This was an amendment to the Medicaid statute. It sets forth minimum standards of care that nursing home facilities are supposed to provide in order to continue receiving Medicaid funding. It is a type of law that's often called spending clause legislation. And what we mean by that is Congress uses its power of the purse, in effect, to obtain agreements, particularly from the states, about certain types of conduct, often regulating perhaps in local ways that it might not be able to regulate even through its broad commerce power, in return for the money. And often the penalty for not complying with the federal requirements would be some kind of a fine or termination of funding. And spending clause legislation is everywhere. Millions of Americans benefit in some way or another through this kind of legislation. Often the money is then dispersed at the state and local levels. So the argument here is there was a violation of this particular type of legislation, and that Mr. Tolevsky could sue for damages and attorney's fees under Section 1983. The district court in Indiana dismissed the case, finding that this nursing home statute is just a regulatory statute. It was just basically a mandate from the government to be enforced by the government. It's not something that private parties can sue about. Went up to the Seventh Circuit, and they reversed, holding that while it's true this nursing home statute doesn't give individuals a right to sue, you don't need that because Section 1983 provides its own right to sue, and it says for any violation of the Constitution or laws, and the nursing home statute is a law. The Seventh Circuit cited a case, kind of a foundational case from the Supreme Court from 1980, a case called Maine against Thibodeaux, authored by Justice Brennan, that in fact said in 1980 that generally speaking, you can use Section 1983 to sue for statutory violations of any sort, given the language and laws in the statute. But, and this is where I was going to kind of say a few things about some other lines of cases, the Supreme Court in a number of areas have, since 1980, pulled back from being very permissive about allowing private causes of action. And so I'll just mention a couple of those other potentially related areas. One is just the question of when can you take a federal statute, put 1983 aside, and claim to be someone who can enforce the statute in, say, a claim for damages or injunctive relief. And during the Warren Court era, the court was quite permissive about that question, basically saying that if it thought allowing us to sue, private parties to sue, would help promote the purposes in Congress's enactment, that was good enough, because more enforcement is better. The federal government lacks resources to do everything. It'd be nice to have lots of kind of private attorneys general enforcing the laws. That is definitely not where the law is now. In a series of cases, probably the most famous is a 2001 case authored by Justice Scalia, a case called Alexander versus Sandoval. The court said that is not the way to approach this question. They've become much more concerned on the court about the fact that adding more enforcement might not always be a positive, that it might lead to over-deterrence, that it might take away centralized control from the federal government, might not actually be consistent with some types of legislation. And they, in fact, require quite a clear indication from Congress that it meant to allow private parties to sue under a federal statute. Without that, you cannot do it. So a big change from the earlier days. Another area that's gone the same direction is the ability of private parties to sue under the Constitution itself for violations of the Fourth Amendment, the Fifth Amendment, etc., for damages in particular. The most famous case there, many of you probably studied it at least at one point, is the Bivens Case from the early 1970s, again authored by Justice Brennan, and broadly allowed, or seemed to allow, damages claims for violations of our constitutional right. But the court has gone in the exact same direction it went in the statutory area and has steadily retreated over the years. Indeed, has not recognized a new Bivens claim under the Constitution in over 40 years. And just last term, in a case called Egbert versus Boole, the court once again declined to allow a Bivens claim under the Constitution, and at least since suggested you're unlikely to get any more from the Supreme Court, that Congress really has to expressly provide them. It turns out, and I won't go into detail on it here, but in my own foreign relations area that I often specialize in, the same trend has happened under a statute called the Alien Tort Statute that had been used for many years for international human rights suits. And the Supreme Court at least seemed to allow the lower courts to go in that direction for some time. And then after about 30 years, just the last 5 or 6 years, the Supreme Court has really pulled that back and largely required more express congressional statement that it really would like private parties to be able to bring those suits. And even last term in a case called Nestle against Doe about slave child labor and cocoa farms abroad, the court again declined to allow an alien tort statute type of claim. Those lines of cases under statutes, the Constitution, the specialized international statutes, all moving in a much more restrictive direction in recent years, poses the question, is the Section 1983 line of cases from this Brennan decision from 1980, is it kind of an outlier? How does it sit with these other lines of cases? And I think that in that sense, it's not surprising the court is turning back to this. It had already retreated, I should note, before this case in a number of ways from that 1980 Maine versus Thibodeaux decision, trying to align the 1983 jurisprudence with these more restrictive lines of cases. And the most famous decision there is Gonzaga versus Doe from 2002, where they didn't quite disallow using 1983 to sue under spending clause statutes, but they did say that underlying statute had to clearly convey rights, not just be purely regulatory, and that if Congress provided other remedies, that might be indication they didn't want you to use 1983. And that's where we are in this Tolevsky case, where we know the court has gotten much more restrictive in general about statutory and even constitutional rights of action. It has precedent, of course, that's still on the books that says 1983, which as long as you find a state actor type of defendant, which is a big if, but does exist in this Televsky case, that you don't have to worry as much about these other lines of cases because 1983 gives you a cause of action, it does, and it expressly references without qualification not only the Constitution, but also the laws. And it's hard to deny that the nursing home statute and any other spending clause statute is a type of law. And that's really where the Seventh Circuit came out in Tolevsky. They said, we understand the Supreme Court has gotten more restrictive in general, but they thought this statute met even the Gonzaga test, the 2002 test about conveying rights. And in fact, this nursing home statute has a list of residence rights for patients, and that's very rights-oriented language. And does it have other remedies? Yes, the Seventh Circuit acknowledged that, but they said they're really just kind of funding cutoffs and administrative grievance procedures, and the Seventh Circuit thought that was not enough of an indication that Congress meant to take away your right to sue under 1983. Where does it stand in the Supreme Court? I've gone through the briefs. The nursing home, not surprisingly, argues that the court should cut back in this area of law, and its argument is that the Supreme Court should disallow suits under 1983 for any violations of spending clause legislation. The basic idea is that type of legislation is more like a contract between the federal government and the states, and people benefit from it, but that's not the kind of direct statutory right that Section 1983 should be designed for. If the court accepts that view, it would require overturning some cases. So this raises questions of stare decisis. We have seen quite recently that this is not an inevitable barrier to Supreme Court decision making. Having said that, the Supreme Court has said that stare decisis is especially strong in the statutory area, unlike, say, in Dobbs with constitutional law, because Congress can much more easily just change the statute if it doesn't like what the court has done in the past. And Congress so far has not chosen to do that. The defendant anticipates that argument and argues that really, if you look at these cases under 1983 by the Supreme Court, they haven't been really about the text. They've been much more like a common law kind of judicial development of the causes of action, and the argument is that merits less of this strong stare decisis than a pure textual decision. That's an interesting argument. I was very interested in reading the Solicitor General's brief from the Biden administration. Where would they come out on this? And they kind of split the difference here. They said to the Supreme Court, please don't overrule all those cases that allow spending clause legislation lawsuits. Don't go with the petitioner on that. There's a lot of cases. Congress might have relied on those in passing some of the statutes and stare decisis. But they still come down against the Seventh Circuit and in favor of the nursing home. The Biden administration argues that this particular nursing home statute, if you think about it, probably wasn't thinking about Section 1983. Why? Because almost all of the nursing homes that would be governed by it are private facilities, something like over 90%. And only a small portion would be state or municipal owned. Given that Congress was likely not thinking about state-owned facilities very much, it probably wasn't thinking that private parties could use this old pro-Civil War statute to go after state actors. And that, the SG argues, is enough of a reason to disallow suit under this particular federal statute, but the SG urges the court not to touch its case law otherwise. And there are many attractions to the SG's argument. If one was inclined to reverse, very narrow decision, does not overrule precedent, leaves intact fully the word and laws, because Congress could always end your right to sue through a later law, if that's what's happened implicitly in the nursing home statute. This is not a court, and I'll just conclude with just a few thoughts of predictive. It's always hazardous to predict anything about the Supreme Court, but people always want that anyway. So I'll sort of offer a couple of tentative thoughts about that. It does seem, I will make a guess that the Supreme Court is likely to reverse, let me put it that way, given that it's not just the petitioner, not just all of those lines of cases that have moved in the other direction, but even the Biden administration, otherwise sympathetic, I think, to a broad use of Section 1983, still comes in favor of reversal, would be suggestions that's probably likely. And then the question, and the hard question, is will they do so if they reverse narrowly or more broadly? And again, we know, for example, that Chief Justice Roberts seems to often prefer kind of narrow rulings, but he does not appear always to be in the majority in that sentiment anymore. One can imagine a much broader ruling here that would more closely align this area with these other restrictive areas of cases. And there is a dilemma, I will say, for some of the textualist justices on the Supreme Court, which there's no indication in the plain text of narrowing and laws to only certain kinds of laws. One has to somehow do more work on that text than just read it. And I do think the legislative history and the context from the 1870s could give you something to work with there to narrow it down. But this may not be, some justices may not feel comfortable going into, say, the legislative history to interpret the plain meaning of a statute. So I think it poses some difficulties for textualist judges. And I also think this whole idea of spending clause versus not spending clause, as the SG points out, can get complicated very quickly. You don't always know whether a statute's spending clause or not. It could be a commerce clause legislation and spending clause. And I think this could make the law much less predictable and murkier. And I think the Solicitor General makes a decent argument that this would be a difficult line to draw by the court, even if you're otherwise persuaded by it. And the final possibility, if they don't go with the narrow ruling, and they might, I think they still might, would be just to say and laws means all laws that provide you themselves with a cause of action. Therefore, you don't have to decide whether it's spending clause or not. And I think that's a possibility. It would completely align this area with the very restrictive cause of action jurisprudence. I would want to know more about the history, whether this is plausible from the 1870s that the statutes that might have been available, they would have been civil rights statutes, would have had understood to have a cause of action of some sort. And if you think that that would have been true then, we can get into questions about this later, under the general common law or something, there's an argument that that should be the regime here unless Congress says something more express. That would definitely require overruling a fair number of cases. But again, this is a court, as people have been remarking, that seems more willing to rethink areas of law in that kind of a broad way. So we will see. Thank you.
I guess I'm the senior person on this panel because this is my 15th year at the law school. So I'll discuss two criminal adjacent cases on the court's docket as well as the case from last term. But first, I really want to share this very exciting update, which is that the students in my federal criminal justice clinic and I are about to publish the first broad national investigation of the federal pretrial detention system ever. And we're publishing a report called Freedom Denied: How the Culture of Detention Created a Federal Jailing Crisis. Our findings are incredibly eye-opening and pretty scary. We document federal judges jailing people pretrial without a basis in the law, detaining people for poverty, and creating racial disparities. We also find, and this is unbelievably shocking, that in 1/4 of federal district courts in this country, poor people can be locked in jail and are locked in jail without lawyers sometimes. And this is a clear violation of federal law and this really kind of dirty little secret that we're about to expose. So as for like why this is happening, we conclude that federal judges and prosecutors have just lost sight of what the actual law is. So there's like the Bail Act here, and all the practice in federal court nowadays is happening over here. And there's this custom and culture that's just completely untethered from the law itself. So our study relies on quantitative data that we gathered in court watching, qualitative data from interviewing 50 federal magistrate judges and other stakeholders. I'm very excited about it. We're going to provide concrete recommendations. How do judges bring the practice back in line with the law? And I've been conveying these findings to hundreds of federal judges, thousands of federal public defenders, going to continue to do that this fall. And my students and I are just very excited to put this out there to you all and to the world and try to sort of combat the institutional pressures and implicit biases that spawned what we call the culture of detention. So now let's turn to two cases on the court's docket. These have serious implications for post-conviction relief. So Reed versus Gertz and Jones versus Hendricks. I'm going to start with Reed versus Gertz. This is also a Section 1983 case, so it connects really well with Professor Bradley's presentation. It's a racially charged case that has very important implications for people on death row and people pursuing exoneration. So Rodney Reed is seeking DNA testing of evidence that he believes would prove his innocence. And the Texas Court of Criminal Appeals denied Mr. Reed's request for this testing, and so he brought a due process challenge in Texas, challenging Texas's DNA testing procedures under Section 1983. So there's this 2011 Supreme Court case called Skinner versus Switzer, and that allows state prisoners to file post-conviction claims under Section 1983 for DNA testing of crime scene evidence. So it's really right on point. But Mr. Reed's case, I mean, it's fascinating, the facts, right? Like, it could have come straight from the pages of Brian Stevenson's Just Mercy or books like that. Mr. Reed is a black man. He was convicted by an all-white jury of the murder of his white girlfriend, a woman named Stacy. And back in 2019, Mr. Reed, he'd been sitting on death row in Texas for 20 years at that point, okay? And he was just days away from dying in what the New York Times has called the nation's busiest death chamber in Texas, when all sorts of people came to his aid, okay? Senator Ted Cruz and the Texas Parole Board and other Republican leaders in Texas, like, they all went to the governor and asked the governor to grant him a reprieve. So Mr. Reed's innocence has also been championed by all these celebrities like Oprah, Rihanna, Beyonce. It's fascinating. He's really garnered a lot of support. So he's convicted in 1998, right? And since that conviction, at least 3 people have come forward with evidence that Stacy was not, in fact, murdered by Mr. Reed, but was instead murdered by her fiance, a guy named Jimmy, who's a former police officer who himself, by the way, recently served 10 years in prison for kidnapping and sexually assaulting a woman in his own custody, right? So Jimmy, not a good guy. And a former cellie of Jimmy's, who's a member of the Aryan Brotherhood, said that he heard Jimmy confess to killing Stacy. And he heard Jimmy say, "I killed her because she was cheating on me with a black man, Mr. Reed." And apparently what Jimmy actually said was, "I had to kill my racial epithet-loving fiance." That was what he said. That was his confession, okay? So a hate crime killing his fiance. The forensic evidence against Mr. Reed is very thin, okay? Like the only evidence the prosecution presented to implicate him was a semen sample, which makes perfect sense because he was in a relationship with Stacy. So the evidence that he wants tested includes various items found at the scene, like Stacy's belt, which was used as the murder weapon. The question in this case in the Supreme Court now is, when exactly does the 2-year statute of limitations begin to run when somebody brings a Section 1983 claim requesting DNA testing of crime scene evidence? Okay, so it's a very big, the issue in the Supreme Court is timing, right? Specifically, did Mr. Reed's Section 1983 claim accrue in 2016 when the state trial court first denied DNA testing? Did it accrue in 2017 when the Texas Court of Criminal Appeals issued its authoritative construction of the Texas DNA testing statute? Or did it accrue at this third point later in 2017 when that court denied rehearing, right? And the only way Mr. Reed can win here is if the court holds that his federal civil rights claim accrued at this third and final point, okay, after the denial of rehearing. If the court holds that the claim accrued rather when the Texas court first, the highest Texas court first considered it, he's gonna lose. So there's a circuit split on this whole question of like when the clock begins to run on a prisoner's civil rights claim. And in Mr. Reed's case, what happened was the Fifth Circuit joined our Seventh Circuit in holding that the injury occurs as soon as the state trial court denies a request for DNA testing, right? Like even if that request and that denial is followed by years of appeals, okay? So very restrictive. Mr. Reed has asked the Supreme Court to instead side with the 11th Circuit, which holds that the statute of limitations doesn't begin to run until this final point, right? Much later, after all state court litigation denying DNA testing has concluded. So under the 11th Circuit's rule, the claim accrues only upon total legal finality of the denial of DNA testing, including, for example, like the Supreme Court denying cert, okay? So it's really hard to say why the Supreme Court took this case, like reading the tea leaves. Like it's possible, kind of related to what Kurt said, that conservatives want to create strict time limitations so as to narrow the window in which people can bring their Section 1983 claims or use Section 1983 to get around some habeas limitations, because that may be what the conservatives see this as doing. But the court considered this case at 8 conferences before granting cert, which seems to suggest that maybe the conservatives weren't like champing at the bit to get their hands on this case. So maybe this case was taken because the progressives want to ensure that the people who are wrongfully convicted have meaningful access to federal review, and maybe they have Justice Roberts on their side. I don't know. But if the court does come out with a rule that's favorable for future prisoners, right, it could be this middle place. It won't necessarily save Mr. Reed because he filed his claim. He may have filed his claim too late for that. And of course, we have to remember, like if the court rules against Mr. Reed, the murder weapon and other evidence will never undergo DNA testing. He will be killed by the state of Texas, right, despite Jimmy's confession to a hate crime murder of his fiance. All right, so that's Reed versus Gertz. Now let's turn to Jones versus Hendricks, which is a habeas case out of the 8th Circuit. So Marcus Jones was convicted in federal court of something that has now been deemed not to be a crime at all, okay? So today, Mr. Jones is legally innocent of the crime for which he's serving 27 years in prison. But we have this like Kafkaesque habeas system, right, which may well make it totally impossible for him to get any relief. I think there is a very good chance the court took this case to deny Marcus Jones's claim, especially because Justice Gorsuch penned the 10th Circuit opinion that's on one side of the underlying circuit split. So the through line of both these cases, Reed and Jones, is that they could result in further limitations being placed on post-conviction relief for people who are actually innocent or have very strong claims to innocence. In the context of Mr. Jones's case, the circuits are again split. They're split over this question of whether somebody who was convicted of something that was later deemed not to be a crime can challenge their conviction in a Section 2241 habeas petition if they have already previously sought Section 2255 relief, okay? So here's the deal. Mr. Jones was convicted of possession of a firearm by a felon, but he's always maintained that he believed that conviction had been expunged, all right? And in 2019, the Supreme Court held in this case called Rahafe that knowledge of one's prohibited status as a felon is an element of the offense. The government has to prove that knowledge. And so the government in Mr. Jones's case did not prove the requisite mens rea, right? They did not prove that he knew he had this prohibited status as a felon, meaning he is legally innocent of this crime. But Mr. Jones couldn't challenge this conviction in a Section 2255 petition, right, because he'd previously filed for habeas relief, and the law bars second and successive federal habeas petitions. So he filed a Section 2241 habeas petition under what's known as Section 2255's saving clause, okay? It's 2255E. And that applies if he can show that 2255's remedy is, quote, inadequate or ineffective to test the legality of his detention. So the Eighth Circuit took a page out of Alice in Wonderland. They held that this saving clause does not apply in these circumstances because Mr. Jones could have argued below that his offense was not a crime, and they said it's irrelevant that that argument would have been an absolute dead bang loser at the time that he would have had to make it below, okay? And there is this a lot of angels dancing on the head of a pin as far as what the word test means, what the word adequate means, et cetera. So the court held, the Eighth Circuit held that in the past, Mr. Jones theoretically could have used Section 2255 to test the legality of his detention, even though he had literally zero chance of prevailing on that argument before Rahafe came down in 2019, right? And he was litigating all this before then. So it's kind of nutty. But the Solicitor General, interestingly, is not defending that. Their Solicitor General is defending the outcome in Jones only, but not its reasoning, which I think emphasizes the absurdity of the Eighth Circuit's approach here. And the SG's position here is that a federal prisoner who is barred from filing a Section 2255 motion can invoke the saving clause, okay, under the following circumstances. First, he has to contend that a new statutory interpretation by the Supreme Court establishes that his conduct was not criminal. So the SG's office says Mr. Jones meets this prong. And second, that he establishes he's actually innocent of the new, under the new definition of the offense. That no reasonable juror would vote to convict. And the SG says they don't think he meets this prong for factual reasons. But when the SG declined to defend the reasoning below, very interestingly, the court took this rare and refreshing step of appointing a woman lawyer as an amicus to support the Eighth Circuit's judgment. This has only happened in 13% of cases where the Supreme Court has had to appoint amicus. And conservatives on the court, I have to say, are unlikely to agree with the SG's proposed rule, right? So we've got Mr. Jones, we've got the SG, and then we've got the Eighth Circuit, and I'm pretty sure the Supreme Court's gonna go with the Eighth Circuit. There's a fairly deep circuit split. We've got 8 circuits on the side of Mr. Jones, 3 on the side holding that no habeas relief is available at all, but the foundational opinion against Mr. Jones, as I mentioned earlier, was written by Justice Gorsuch back when he was on the 10th Circuit, and his position is essentially identical to the Eighth Circuit's. It really is. He says the saving clause is simply unavailable to any petitioner who could have made the relevant argument, even if circuit precedent was totally against them at the time, even if it would have been a totally Pyrrhic argument, right? So I think this case will likely continue the court's trend of narrowing habeas relief in recent years. And yeah, I'm just gonna say one final, just really quickly to conclude, I want to mention the case of Concepcion versus United States, which came down in June. So in Concepcion, the court held that when someone who is serving a federal prison sentence brings a motion to reduce their sentence under the First Step Act, the sentencing judge is required to consider any intervening changes of law and fact that the person raises. And so there's this very interesting post-Concepcion circuit split that's developing. And it has serious implications for my clinic's efforts to win compassionate release for clients serving long federal prison sentences for conspiring to commit a fake crime. And so we did litigation, race discrimination litigation a number of years ago on behalf of 43 clients charged in these fake stash house cases. And most of our clients were released. They were spared 15 to 25-year mandatory minimums that they'd originally been facing before we got involved. The New Yorker did a great piece about our litigation last year, actually. But since then, we have won compassionate release for a number of people who couldn't benefit from our litigation because they were already in prison serving these really long mandatory minimum sentences, decades-long sentences. That work's being led mostly by my colleague, Professor Erica Zunkel, in the clinic. But I wanted to mention this because the post-Concepcion circuit split that's developing with the Seventh Circuit, our circuit, on the sort of bad side for us is really interesting. And I'm happy to answer questions about that during the Q&A. Thank you.
Gonna time myself because I don't always do a good job of that. Okay, so I'm gonna take a very different turn to some of the major doctrinal tensions that are lurking after the last term and that are likely to come up in the next 12 months. So we've known for some time that the Trump Supreme Court nominees are going to place additional judicial scrutiny on the administrative state, work to scale back agency authority to make policy, and limit agency discretion. After the last term, we have a better sense of what this will look like in practice. Much of the academic and journalistic commentary has focused on the non-delegation doctrine and the major questions doctrine. The non-delegation doctrine says that Congress cannot delegate the legislative power to agencies. And by the legislative power, the court typically means prospective rules of general applicability. I think this is a misdefinition of the word legislative, but let's bracket that for the time being. While a few members of the court have indicated that they are interested in reviving the non-delegation doctrine, West Virginia versus EPA dodged or at least forestalled the non-delegation question and used the major questions doctrine to limit EPA's authority to regulate carbon dioxide. So West Virginia v. EPA was a very significant case both for climate regulation and also for sort of larger theoretical questions about how agencies fit in doctrinally within the separation of powers. The nominal question of the case was whether the phrase best system of emissions reduction in the Clean Air Act allows generation shifting, what is colloquially known as outside the fence line regulations, or whether EPA can only regulate carbon dioxide by considering what technologies could feasibly or cost-effectively be installed in particular generation facilities. In other words, can EPA say the best system of emissions reduction is moving from coal to gas, switching technologies, or does it have to look at what's technologically feasible to install in a specific power plant? One thing that was notable about this opinion, West Virginia v. EPA, is that the Supreme Court acknowledges in a single sentence that generation shifting requirements can be, and I'm quoting, can be described as a system, which is what the statute authorized the agency to establish. In other words, 10 years of debate about the word system and whether it could authorize this, the Supreme Court took the progressive EPA vision and said, okay, let's move on and deal with the bigger separation of powers question. But despite conceding that question, the Supreme Court announced a clear statement rule that directs courts, before discerning the plain or obvious meaning of the statute and using ordinary tools of statutory interpretation to discern what the statute means, to first require explicit and specific congressional authorization when a policy is has major economic or political significance. So what I want to do is talk about what I think of as some surprising implications and tensions that the major questions doctrine raises that are coming up in a few cases this term, and specifically think about what it means for how the court thinks about statutory interpretation, environmental policy, and the administrative state more generally. So the first question is narrowly focused on climate. But from a climate perspective, I wonder if the court has put EPA between a rock and a hard place. And what I mean by that is not, oh, this makes it hard to do environmental regulation, but that the previous 20 years of Clean Air Act regulations had instructed the EPA to regulate in precisely the way that it regulated in the Clean Power Plan. The major Clean Air Act Supreme Court cases, from Massachusetts versus EPA to Michigan versus EPA to UARG, said the EPA needs to consider cost when regulating. It needs to look at things like emissions trading schemes and be very, very attentive to how significant and onerous a policy is on industry. So EPA's justification in the Clean Power Plan was, this is just cheaper and more sensible. Now, after 20 years of the sort of first line of precedent, the Supreme Court says, well, this big trading schemes, that's a major question, and you don't have authority to do that. So this creates an interesting tension that I think has been a little bit underexplored of what can the EPA possibly do? Can it square its new authority under Section 111 about how to regulate stationary sources if those have to be inside the fence line? And we've already been told that these sorts of inside the fence line regulations are less cost effective than what EPA tried to do here. Is there any way for EPA to regulate climate? A few sort of interesting things that I think are worth commenting on about this. The Inflation Reduction Act, which is arguably the most ambitious climate legislation in history, basically sidelines the EPA. It makes the IRS, the Department of Energy, and FERC the climate regulators of first impression. And I wonder if, to what extent, the court's skepticism of EPA is relevant here. Second, there are a few cases, there's one Supreme Court case that EPA is involved in, the definition of waters of the United States, but there are also a couple cases likely to reach the Supreme Court in the next year or two where EPA is considering how to regulate in the wake of West Virginia versus EPA, and I think we'll at least get more information. So the first is, under the Clean Air Act, the EPA can set auto emission standards, but there's a waiver to California that allows California to set higher standards. This is already being challenged. The EPA's started methane emissions regulations and also a variety of other vehicle emissions regulations. And I think some of these look like they're going to take some emissions trading schemes. And I am curious about what kind of argument will be used after West Virginia v. EPA. Question two, to sort of take a theoretical turn, is what is the court doing with Chevron? Typically, when courts review agency interpretations of federal statutes, they ask, is the statute vague? If so, is the agency's interpretation a reasonable one? The vagueness question is just known as Chevron Step 1. The reasonable question is Chevron Step 2. Scholars have coined the term Chevron Step 0 to ask all sorts of things about whether this falls under the agency's jurisdiction in the first place. But what's notable about last term is that the Supreme Court never used Chevron deference, ever. So there's a threshold question of, has the Supreme Court overturned Chevron sort of sub silentio? But the second question is, what does West Virginia v. EPA mean for Chevron? You can think of it as sort of a Chevron step negative one. I don't know, we'll have a million Chevron steps in 2 years. But the reason it's arguably a Chevron step negative one is that in order to apply the traditional tools of statutory interpretation now, we first have to ask, is this a major question? And if so, is there an extra clear statement suggesting that the court has delegated this power to the agency? And so there's this, I mean, I think there's a tension with textualism there because we don't look at the plain terms of the statute when we're asking, is this a major question? In order to do the ordinary textual interpretation, we first have to see if is it major, and if so, is there an extra clear statement? But note that the West Virginia v. EPA didn't mention Chevron once. It just applied this before going into the Chevron analysis. And so because I study some statutory interpretation, a lot of administrative law, and even more environmental law, conveniently for today, there's a environmental case that I think is going to make this Chevron question quite explicit, and the case is Sacket versus EPA, which is about the definition of waters of the United States. This is an extremely long-running dispute between various justices about whether waters of the United States can refer to wetlands, whether wetlands have to be adjacent to other bodies of water. And if we want, I can go through the whole procedural history. There's a 414 decision, so we have to look at a very opaque Kennedy decision to try to discern what waters of the United States means. But the last time this was before the court, Chief Justice Roberts said, this is an obvious Chevron question. Who knows what waters of the United States means? But the statute is vague, so we should just let EPA solve the muddle we've made for ourselves. So. But all the thing that's interesting is Roberts was not a majority opinion, and when the Supreme Court has previously tried to construe waters of the United States, Scalia said, well, waters of the United States obviously means navigable waters, waters where you can sort of sail a boat. The four-justice minority said, no, waters of the United States means those things that we want EPA to be able to regulate, and Justice Kennedy had a balancing test that is lost on me. But neither Scalia nor Kennedy said we should do Chevron. It was really only Roberts. So this to me seems like a classic Chevron case, but there's a high likelihood, I think, that the Supreme Court is just going to tell us what to do. So I think I think there's a real possibility that the court will simply overturn Chevron in Sacket without even mentioning the case. So that's the second question. The third question, and the one that I think is the most interesting, is whether West Virginia versus EPA suggests that there's a growing tension between two strains of, I guess, conservative administrative law thought involving the separation of powers. And what I mean by this is, the first is the unitary theory of executive power, which holds that agencies are legitimate in the US constitutional system because they're subject to presidential control. Rather than being a sort of freewheeling fourth branch, the president, through removal, is able to supervise agency actions. And this means that we don't have a sort of scary fourth branch. This is a formalism I'm sympathetic to, and one I'm a little bit less sympathetic to is the non-delegation strain. But the second thing that I think is I'm going to draw out the tension is whether the non-delegation doctrine or the major questions doctrine is in some tension with the unitary theory of executive power. And the reason I think West Virginia v. EPA sort of suggests that this tension exists is that in West Virginia v. EPA, the majority tells us that to discern whether an agency action is a major one, courts should look, one, at early agency practice. If the court did this thing, if the agency did this thing when the statute was initially passed, that is evidence that the agency has authority to do this. And the second piece is the court said we should look at how much controversy there is today to see if the agency action is a major one. And so taking the Supreme Court at its word, I think these are in tension with the unitary theory of executive power, because the justification of the unitary executive thesis is that the president is the most accountable branch, and when the people want policy changes, they elect a new president, and presidential oversight is the means by which the president can change what the agency does. But if we freeze in time what the agency's authority is based on what the first agency that had this authority did, if agency actions are less likely to be vague, and if the agency is less likely to be able to change its mind about something, then later presidents are less able, through agency oversight, through the supervision of agency officers, to dictate agency policy in the future. And so electing a president, EPA does something in 1990 after the Clean Air Act is amended. The next president, this is when, the first Bush was was president during the sort of last major Clean Air Act reforms. And when there's a new president, that president has less of an ability to control agency heads. And so I think this unitary executive major questions tension is actually front and center in a case that's not before the Supreme Court yet, but I'd be really surprised if it didn't end up there. And that's a case called Jarkese versus SEC, which is a Fifth Circuit decision about whether SEC administrative law judges are unconstitutional for a whole host of reasons, and is now en banc before the Fifth Circuit, but I suspect will come. And so what? So here's what Judge Elrod said in the opinion in Jarkese. Congress has given the Securities and Exchange Commission substantial power to enforce the nation's securities laws. It often acts as both prosecutor and judge, and its decisions have broad consequences for personal liberty and property. But the Constitution constrains the SEC's powers by protecting individual rights and the prerogatives of the other branches of government. This case is about the nature and extent of those constraints in securities fraud cases in which the SEC seeks penalties. The SEC brought an enforcement action within the agency against petitioners for securities fraud. And so the question is whether the SEC's use of ALJs, so the Judge Elrod holds, one, that SEC's in-house adjudication of petitioner's case violated their Seventh Amendment right to jury trial. I'm going to bracket this question because I don't know very much about the Seventh Amendment. It's my understanding that there's a direct on-point Supreme Court case for this. But two, whether Congress unconstitutionally delegated legislative power to the SEC by failing to provide an intelligible principle by which the SEC would exercise the delegated powers in violation of Article I's vesting of all legislative power in Congress. And three, whether statutory removal restrictions on SEC ALJs violate the Take Care Clause of Article 2. Judge Elrod agreed with Judge Oldham and found that all of these were violated. But you'll note that there's one reason of invalidating this is the non-delegation doctrine, and the other is that the president lacks official oversight of ALJs, and so these are inconsistent with the unitary executive thesis. It's unclear to me. It's possible that en banc the Fifth Circuit will uphold it on narrower grounds, but I think if the case goes before the Supreme Court, we will at least get a taste of how the court thinks the non-delegation issue squares with the unitary executive issue. And I think it's possible, the narrowest way one could decide this is just the officer question. It's the easiest and the cleanest. But to the extent that the court really does want to go to the non-delegation issue, there's a possibility that we get that. So I just wanted to tee up that sort of theoretical tension. And then the final thing I want to talk about is, every time there are justices who want to push the law in a certain direction, they sort of presumably will take cases that will allow them to do so. But there's been a kind of an unusual willingness to look over procedural infirmities to move the doctrine where the court wants it to go. So in West Virginia versus EPA, to come back to the case I started with, there were a lot of reasons this case should not have been before the Supreme Court. The case had been stayed by the earlier Supreme Court. The Biden administration said they're not even going to do the Clean Power Plan, so arguably the whole case was moot. And yet the Supreme Court said we're going to take it anyway and reach this decision. Similarly, I think with, Chevron has been described as the most significant administrative law case in history, and if the Supreme Court is overturning it, it would be useful to know what it's replacing it with, and sort of the potential to be overturning Chevron silently is an unusual procedural device. And in Jarkese's non-delegation arguments rely on what the Fifth Circuit thinks is likely to be the non-delegation doctrine given future Supreme Court cases, because the intelligible principle test had not really had teeth since 1935, and the Fifth Circuit says, well, now here's why I think it has teeth. And so I as a just sort of court-watching nerd, I'm just interested to see whether there's this continued willingness to sort of reach to hear cases the court wants to hear because the court wants to move the law in a certain direction. And that's sort of what a somewhat interesting, I think, trend that's occurred in really increased in the last year. So that's what I have. Thank you all.
Thank you. Thank you, Kurt, Allison, and Josh. So we'll now open up for questions from our audience. One procedural process here for us to ask our questions. This event is being video recorded, and it will be placed on the law school's website, so your classmates and friends who weren't able to be here today can see it. But of course, we want to capture for that audience your questions. So a member of the law school team will be passing out a handheld microphone, and of course, please raise your hand. Or I can call. Yes, please.
Okay. I submitted my question online, but I will repeat it. Do you think now it's accurate to describe that Justice Alito now can freely speak his mind now that he no longer needs Justice Roberts' vote? Thank you.
Who'd like to tackle that one? We're starting with an easy one.
I will note just a couple of quick thoughts on that. Alito is not the only justice to have made remarks in the last decade or so that kind of go beyond just descriptive statements about what they're doing on the court. His statements recently, responding to criticism about Dobbs in particular, obviously made some press. I will note that Ruth Bader Ginsburg, for example, was fairly outspoken before her death. And so it raises questions about what justices ought to be doing besides issuing decisions and deliberating, and whether they ought to have much of a public presence, and we probably have differing views about that. My own personal view is that part of the trade-off of being a justice is you kind of have to live a bit of a monastic life and not be a public figure. And of course, it's not the first time that Justice Alito has made statements or given his, indicated his views. You may remember a State of the Union address, for example. He seemed unhappy at one point about certain things being said about the Supreme Court. So I'm not entirely sure this is either new or unique to him. But I think your broader question is whether, just as a matter of decision-making, there might be less compromise because we now have a different alignment on the court. It's more conservative. For a brief period of time, we had the Roberts Court. Roberts, as an institutionally minded justice, as Chief Justice, I think you're more likely to be that anyway. And he's just not in the majority on some of these key decisions. And as a result, his preference for smaller steps, more institutionally minded kind of approaches, even though he is conservative, is probably not the dominant mindset of the court. And so justices who are more conservative, like Alito and Thomas, certainly in their decision-making, I think, see more opportunities to decide the way they think the law really ought to be, and not make maybe as many compromises as they would have in prior times. That's just, no, maybe, I think Thomas, by the way, hardly ever made compromises anyway, but he was often in dissents with only a couple of justices. But, you know, the composition of the court has changed, and so I think you're seeing that in the decision-making. And Dobbs, of course, has gotten a lot of commentary. Chief Justice Roberts' approach was not followed there. It was a much broader decision about abortion issues, and you know, went as far as it could go, basically, in overturning the decision and not just upholding this particular law before them. And I think, at least in my view, we're going to probably see more of that.
Other questions? Yes. Wait for the microphone, please.
West Virginia versus EPA opinions, and particularly comparing the majority opinion with the two-justice concurrence, and your own view as to whether the major questions doctrine can be squared with traditional case-by-case analysis of to what extent does a statute reflect a wide-open delegation to an implementing agency or tightly regulated discretion to an implementing agency.
Yeah. So I think, Justice Gorsuch writes, the major questions doctrine we should think of as constitutional avoidance. It's in the service of the non-delegation doctrine. My guess is the reason Roberts wrote the majority opinion is not everyone was willing to go there yet. And there has been this open question of what is the relationship between the major questions doctrine and the non-delegation doctrine? Is the major questions doctrine the non-delegation doctrine by another name, or is it a canon of statutory interpretation? I don't think the Supreme Court revived the non-delegation doctrine in the major questions doctrine. I think that whether this is better or worse or equal, I don't know, but I do think that one thing that I don't like about the major questions doctrine is that a defense of a sort of formalist approach to separation of powers is it lends itself to judicial certainty. And I don't see how the major questions doctrine lends itself to judicial certainty. So there's an anecdote I really like that may be too detailed, but shortly after Dodd-Frank was passed, there was a mistake in the drafting where in something called the Lincoln Amendment, banks would be required to divest themselves of their swaps units. Now, there was a deferral period that said insured depository institutions have 2 years to comply with this. Presumably, this should have applied both to insured depository institutions and all financial institutions, but unfortunately, only insured depository institutions had the 2-year deferral period, which means that all foreign banks would have to immediately sell billions of dollars of assets, and it would have immediately caused a global recession. So the Federal Reserve says, when we're going to invent a principle of statutory interpretation that's like, don't cause a recession. And the Supreme Court says, I really don't want to touch this with a, and not the Supreme Court, the Second Circuit says, I don't want to touch this. And, but of course, there's nothing you can think of that's of greater economic significance than should we immediately cause a global financial recession. And yet the opposite of the major questions happened. We said, we're just going to defer to the agency because they know better than we do. And I think this anecdote is interesting because what the Supreme Court means by major questions doctrine to me is an open question. Is it, these are things the Supreme Court cares about? Is it, what is a major economic significance? We have very little guidance about that. Whereas with the non-delegation doctrine, I think you can, there may be disagreement about details, but you can intuit what is the vision of the legislative power that underlies the non-delegation doctrine, whereas I take the major question doctrine to be an invitation to judicial discretion that's not good for industry, because industry would prefer certainty about what the law means rather than uncertainty about when the Supreme Court will get involved. It's not good for me just trying to predict what the Supreme Court's going to do. And so I think to the short version of your answer is I think the major questions doctrine differs from the non-delegation doctrine and other options because it really does suggest a kind of case-by-case judicial determination of what I think or feel is major. And I think that is deeply uncertain and much more case-by-case development than you would otherwise have. So yeah, this is a really interesting point. Whether something can, my understanding is that when Congress enacted the Clean Air Act, people did not think carbon dioxide, at least in the 70s, carbon dioxide was a major question. So you raise, I think, a very profound point about what is the relevant time period. If carbon dioxide was a not major question in the 1970s, does the fact that it becomes a major question in 2020, is that inconsistent with originalism? Should we look at the relevant time period? And whether there's the majorness being sort of adjudicated, 40 years after the statute was passed, also seems to be a tension with some of the jurisprudential approaches of a couple members of this court.
Other questions?
Hi. Sorry, Josh, I'm going to pile on you, even though I found everyone's comments very insightful and interesting. And I wanted to talk about briefly your point about Chevron. I mean, I agree with your criticisms of West Virginia and the major question doctrine, but to the extent you accept it as a clear statement rule, wouldn't that just be a normal tool of statutory interpretation under Chevron step 1, or step 0 rather, which relates to the extent the court wanted to use this case to overrule Chevron, wouldn't they have said so? I mean, I personally think there are obviously people up there who would like to, but it seems really unlikely that if they had the votes to do that, they wouldn't have just done it.
Yeah. Well, and famously, Justice Scalia was both the most ardent defender of Chevron and never used it because every statute was clear, according to Justice Scalia. So I do think it's interesting how the major questions doctrine has evolved. I sort of skipped this part, but the major questions doctrine, the modern version of it is often traced back to Brown and Williams and tobacco, in which the Supreme Court held that the FDA lacked authority to regulate tobacco. And one reason it said this is that it found the statute was vague. It found that Congress gave other agencies authority to regulate tobacco, so that suggested that the FDA did not have authority. And then it said, given the significance, we think it's unreasonable. But note that the major questions doctrine starts at Chevron step 2. It's about the reasonableness inquiry. It's not about the scope of agency jurisdiction. The later major question, the sort of next two major questions doctrine are King versus Burwell, the eviction moratorium, and the vaccination requirement. And at each point, the court sort of moves Chevron to an earlier point of moves the major questions doctrine to an earlier stage of the Chevron inquiry. By the eviction moratorium, it's starting to look like a clear statement rule, but in King versus Burwell, which is the healthcare case, it's still a reasonableness question. Whether the court is just overruling Chevron or not, I suspect you're right that Roberts and Kavanaugh just don't want to be that explicit about it. But if we're requiring such a clear statement rule in order to get to, it certainly introduces uncertainty to me about when Chevron kicks in, given how unclear it is to know whether the question is major or not. And coupled with the fact that the court didn't use Chevron a single time in the previous term, I think either Chevron has been overturned or we have a court that's more comfortable with textual determinacy and with the court saying what pieces of text result in determinate answers, that we're going to see a lot less Chevron in any event. But it does raise, and I'll stop talking in a second, like interesting questions about, presumably Chevron is, you might think it's actually a proto-separation of powers argument that the agency is not doing a legislative act, it's implementing a statute that has been passed, and if the court doesn't think that's happening, it's a less agency deferential court, and it has a different vision of separations of power.
Well, waiting on that, I'll just make one remark to add what Josh was saying. We're focusing on the Supreme Court. That's the topic. But I do always like to remind my students they take 60 cases or so a year. Almost all the cases, including most of the interesting ones, are decided by the lower courts. And this is one of those phenomena where I think the lower courts are still using Chevron. It still actually has a life. Just turns out you only see it if you kind of look below the Supreme Court at the moment. And that's actually an interesting story in itself, where we might have possibly no real Chevron deference doctrine among the Supreme Court, but maybe one that's reasonably active where most of the cases actually take place, and how long the Supreme Court would be willing to let that regime, if that were the regime, continue. I think it's another interesting question.
Let me just add a footnote to that, sorry. But it seems like the Fifth Circuit and the 11th Circuit have followed the Supreme Court, and the DC Circuit is using Chevron all the time. So we seem to have a circuit split in how Chevron-like we're being. And that's consistent with what Kurt said, but is a sort of another interesting little wrinkle on that.
I think we have time for one more. Well, if no one has one, I have one. So what I'm wondering is, Kurt, as you mentioned that the court takes about 60 cases a year, do you think that is going to change in terms of the volume of cases that the court will take? And I guess part two of the question, and we can do this as a lightning round down the road, do you think this will be another term in which we have blockbuster sort of opinions, or is this one where, given the conversation here, one of the common threads that runs through all three of your sets of comments is about restricting access to courts and that is one that oftentimes I think is certainly very important for our legal system, but is one that doesn't have the same public salience as some of these sort of blockbuster opinions we've seen in recent terms. So volume of cases the court might take, and do we think this is going to be a term filled with blockbusters, knowing, of course, that cert could be granted on any number of things in the next few weeks?
Maybe we'll just go down the line real quick here on that. I don't have a strong view, hopefully my fellow panelists do, about the cert grants. When I clerked, it's been quite a while, for Justice White, anybody who knows about him may not be surprised. He was always complaining they didn't take enough cases and always getting cranky, annoying other people, I think, at the Supreme Court, trying to urge them to take more cases. But they were taking about 100 per year at that point. I mean, he thought that was way too low because he remembered the days when they took close to 200 cases a year. I don't know as a law clerk how they even managed to do that much work. They've been down to between 60 and 80 for quite some time. I'm not yet seeing any particular reason to think they want to substantially increase their workload. There are a lot of circuit conflicts or quasi ones where, quite frankly, they probably don't have strong opinions where they feel like they need to intervene, and the number of cases that they probably feel that way are probably still pretty small. In terms of blockbusters, we've picked out a few partly of cases that might not be quite the big blockbusters of the term. We didn't mention, for example, there are two related affirmative action cases. This is a potential big blockbuster case that a lot of people are following. And then ones that are reasonably big include an election case out of North Carolina about whether there's any review that state courts can have over how these partisan gerrymandered maps are drawn by state legislatures. That's a huge election issue. And there's actually some other ones we didn't mention, like there's a big case about whether California or other states can protect humane treatment of animals through limiting what kind of, in that case, pork could be sold, and there are big conflicts over whether states can try to regulate things like animal welfare or whether they just get preempted automatically, and that's a pretty big case as well. So even though we didn't touch on all those, I see some big ones coming, actually.
So I'm not really sure about how much cert will be granted. I think one thing that's really interesting to me as a federal criminal practitioner is there's a lot of it feels like there's a lot of cases percolating up that are related to ways in which Congress has changed federal criminal law over the last couple of decades in ways that actually help people who are charged with and convicted of federal crimes. And what I'm seeing is a lot of circuit splits and a lot of litigation and a lot of cases coming up to the Supreme Court around those issues, like the Concepcion case that I mentioned, where, for example, the changes I'm talking about are things like Congress recently eliminated an enhancement for, you used to get a 10-year mandatory minimum if you were charged with a certain amount of drugs, right? But if you had a prior conviction, even for any kind of drugs, like even simple possession, you'd get an additional 10-year mandatory minimum and you'd be at a 20-year minimum possible sentence. And Congress recently eliminated that minimum. And there's a real question of, now that that's been eliminated, what can be done by federal courts considering so-called compassionate release motions, which are motions by people serving very long federal prison terms, who want to get out of prison early. And there's just so much litigation percolating at the lower courts, the courts of appeals, circuit splits developing, and then to the Supreme Court on these kinds of issues of how much discretion do federal district court judges at the sentencing stage and then at the compassionate release stage have to change or reduce very, very long sentences. And so I just think that's something fascinating, and I'm seeing a lot of cases that, we're seeing a lot of that litigation. And one other thing I'll just say on this federal criminal front is there's some very interesting bedfellows also. So I think we've all been talking about, often there's, it's the 5 and the 4, or the 5 or the 6 and the 3, right? But like in this Concepcion case, it was, the opinion of the court was written by Justice Sotomayor, joined by Breyer and Kagan, but also joined by Thomas and Gorsuch, right? Really interesting. And on the other side, you have Roberts, Kavanaugh, and Alito, and Barrett. So just some interesting, I think it's worth all of you who are interested in the court looking at the way things break down in the federal criminal context or in the criminal context in general that are just sort of different than the way the justices break in other contexts.
So in terms of, I think it'll be a really active term. I think that the independent state legislature doctrine, I think there's the affirmative action stuff, somewhat less, cases that have gotten slightly less press, but I think are very, very important as well, is there's a Dormant Commerce Clause case coming down, which is, I think, going to be quite interesting for the reasons Allison mentioned. Gorsuch has highly unusual Dormant Commerce Clause views that don't align with some of the other. And then finally, in terms of cases, I spent a lot of time, obviously, talking about agency, the Supreme Court's relationship to administrative agencies. These cases, there are a few takings cases that might have an interesting relationship with agency action, and are we going to regulatory takings world is something that I also think is, the types of skepticism the court expresses to agencies is likely to be a little bit broader than it was in the last term. In terms of Tom's capacity question, I think it's really interesting and complex because to me there are a couple things that are involved in the capacity question. One is just how many cases does the court grant? But as we know, there's both how many courses does the court actually hear, and there's also what our colleague Will Bode has coined the shadow docket, and how active the court is without issuing decisions. And to the extent that number is growing, you might think that's a more aggressive court. That obviously the salience of the cases matters, and I think that we have highly salient cases. And then you have how are lower courts responding to the court, which I think is not as easy to pin down as I sort of initially thought, because on the one hand, you have some recent appointees who are taking, I think, the court's willingness to change, to do new things as a license for them to sort of pioneer that. On the other hand, I think you might see judges who don't want to go in that direction. You have there might be some intransigence. The Ninth Circuit is sort of famously overturned. And so the last question is just, how do lower courts respond to the Supreme Court? And I think it goes in two different directions depending on the circuit and the specific judge. And so that's a long way of saying I don't have an answer.
Well, please,
on Josh's point, just also interesting how state Supreme Courts are responding to the court. It is fascinating. I mean, Texas just thumbed its nose like crazy at the Supreme Court in this case called Andrews versus Texas. It went back down, and it was unbelievable what happened at Texas. Completely flew in the face of what the Supreme Court had told Texas to do in this case, and they're gonna kill this. They're gonna put this guy to death against what the Supreme Court majority said to do, basically. And Arizona also, Cruz versus Arizona, another case up there this term. Arizona's just been thumbing its nose at the court for years on particular criminal issues. So the Supreme Court, it's fascinating.
Great. Well, I want to thank all of our alums and friends for joining us today. And please join me in thanking one more time this amazing panel.